A prayer for listing of two petitions in the admission column. It was last posted in the month of 4th of June 2025.
Okay, give it to the court master.
Lordship.
Give it to the court master.
Lordship. Obliged.
My lord, I pray for listing of a motion item tomorrow, my lord. It's a tender matter. We're technically disqualified, my lord. The price bids are yet to be opened.
Okay.
Tomorrow, my lord. I'm grateful, my lord.
May I please, your lordship, with the consent of the other side, I beg to mention item number 4, lordship. In this matter,
Four.
Mr. K.N. Chaudhary has some personal difficulty today, lordship. May be taken after some day,
After?
lordship.
After what time?
After 2 weeks, lordship.
Okay. Mr. K. Jain.
Lordship on 25th.
So maybe in March.
Lordship.
March or something. Mr. K. Jain, Learned Counsel, paying for the petitioner, has submitted that Mr. K. Chaudhary, Learned Senior Counsel, who is leading in this case, has some personal legal stuff. It is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer stuff as sought for and release the case on
11-3.
11th.
Lordship. Much
May I
obliged.
please, your lord. The consent of other party, I beg to mention item number 7. I have
7.
item number 7.
You are for the
I'm for the petitioner. Your lord.
petitioner.
And for the response.
Okay. Miss
P. Agarwala.
E. Agarwal, Learned Counsel, appearing for the petitioner, has made a prayer for adjournment with the consent of Mr. E. Gugoi, Learned Counsel for the respondent number 2. So, Ms. Ayudas, Learned Additional Senior Government Advocate, who is in attendance, has agreed to the said prayer. So, has paid for how much?
4 weeks time.
Okay, lays the case after 4 weeks on the date to by the office.
Get me.
Huh?
Get me.
Okay. Interim order is there.
Yes, Lord.
Okay, lays the case on so and so. The
20
interim order,
Obliged.
if any, shall continue till the next last idea.
May it please your lordship. Lordship, with regards to item number 12 of the daily list, we had circulated an adjournment request to your lordship with the consent of the other side.
Okay,
Therefore, I pray this matter may come up after 2 weeks, your lordship.
okay. Mr.
T. Kashyap, your lord.
T. Kashyap, Learned Counsel, for the petitioner, has made a prayer for adjournment with the consent of the Learned Counsel for the respondents.
For the petitioner, your lord.
You are for the petitioner,
Petitioner.
you have informed the other side.
For respondent number 5, your lord.
Yes, Miss
Respondent J. Bush.
Learned Counsel for the respondent number
5.
5. You are for whom? Okay, respondent number 5. Okay. Who is in attendance, has agreed to the said prayer. So, Ms. Yudas video. Lays the case after 2 weeks.
2 weeks. Whatever date may be fixed.
9 in March.
10th. May I pray for 11th of March, your lord. There is no difficulty.
11th of March.
Much obliged.
Please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 18 and 19. We need to file a short additional affidavit in the matter. If we may be permitted 4 weeks time.
If you are for the petitioner,
Petitioner in item number 19 and respond number 5 in item number 18.
18, my lord, I am the petitioner, and in 19, I am the respondent number 4.
Mr. K. Mohammed, Learned Counsel for the petitioner in 18 and for the respondent number 4 in 19 is present. Mr.
D. Khan, your lord.
Learned Counsel for the petitioner in 19 and respondent number 4 and 5 in 18 has made a prayer for adjournment as submitted that the petitioner in which item you want to file affidavit?
Your lordship, 19.
And petitioner in needs 4 weeks time to file an additional affidavit. So, which prayer is not objected to by the Learned Counsel for the other sides. Leaves the case accordingly after 4 cases after 4 weeks.
Obliged.
Supplementary list for withdrawal, item 15.
May it please your lordship. Lordship, I have instruction to withdraw the case.
Okay, Mr. H. Burangohai, learned counsel for the petitioner, has submitted that he has instruction to withdraw the request. First of, in view of the above submission made by Mr. Burangohai, learned counsel for the petition is dismissed on withdrawal.
Bless.
For motion, item 16.
May it please your lordship. The petitioner is agreed by the rejection of his technical bid, my lord. My lord,
What is
can-
the NIT?
have a look at page 21, my lord.
Yes.
So this is the name of the work, my lord, construction of 33 kV dedicated feeder. My lord,
Okay.
kindly consider, my lord, the value of the work, 14 crores, 50 lakhs, my lord. Your lordship got it.
Feeder. Huh.
My lord, in terms of the eligibility criteria, my lord, kindly come to page 31 for a moment.
Page 31.
31. The eligibility condition starts at page 30, my lord, qualification of bidder. And for our purpose, my lord, 4.5A, small Roman a. To qualify for award of the contract, each bidder in its name should have in the last 5 years as referred to in appendix, satisfactorily completed not less than 90% of contract value as a prime contractor or a nominated subcontractor where the subcontractor involved in execution of all main work systems, provided further that all other qualification criteria are satisfied. At least one similar work of value not less than amounting to rupees 11 crores 60 lakhs 44,000. So, my lord, the requirement is the work value your lordship has seen it's 14 crore 50 odd lakhs. The 80% of it come to 11 crore 60 lakhs.
Hmm.
Now, my lord, the requirement is, my lord, that he should have a completed work of such and such, my lord, around minimum 11 crores. My lord. Now, while submitting our bid, my lord, at page 129, if your lordship. But this is the completion of work, my lord, we have submitted, my lord. The total works come to 13 crores 56. But if your lordship would kindly see, this work order has been issued to, at the top, my lord, left-hand corner, Assam Electric Store, RNB Road, Kokrajhar, JV Purvanchal Enterprise. So, my lord, this work we has executed, my lord, as a joint venture.
Hmm.
So, my lord, while considering our, my lord, bid, my lord,
This is part of the bid document.
yes, part of the bid document. But there is no dispute as regards that certificate, my lord. Now, if your lordship would kindly come to page 215, my lord, the minutes. It's minus dated 21/1/2026.
Yes.
But four
21,
bidders had
21?
participated. 215, my lord. Annexure 7.
Ah. Yes.
It's a minus dated 21/1/2026 minutes. But total of 4 bidders had participated, my lord. Out of which, my lord, your lordship sees serial number 1, my lord. But it has been elected as the sole technically qualified bidder. 2, 3, 4, my lord, bid has been rejected. Now, my consideration at serial number 2, Assam Electric Store, my lord.
Hmm.
The bidder has submitted the joint venture single similar electrical works executed under APDCL. The share percent of joint venture partly could not be ascertained from the available submitted document. In the meantime, the contractor had willingly submitted joint venture agreement between Assam Electrical Store and Purvanchal Enterprise, which share 90% and 10% respectively. But this document is not part of the contract agreement with APDCL and thus could not be accepted for evaluation. On considering of the same, the committee decides the bidder is technically non-responsive. Now, what has happened, my lord?
This document is not part of the
Bid document, my lord.
contract document or bid document?
The JV agreement, my lord.
No, this document is not part of the contract agreement with APDC.
Yes, my lord. This is not part of the contract with APDCL. What they say, my lord, that it could not be, my lord. That's why I am going to your lordship, my lords. Now, my lord, we had submitted one representation on 9/1/2000. My lord, last date of bid is 31/12, my lord.
31,
12.
12.
But on 9/1, my lord, we submitted a representation giving a clarification, my lord, annexing with that a joint venture agreement dated 30th of December 2019, which we has executed in that. If you lordship
Which
kindly
page?
see page 202.
Where is your representation?
But my representation is page 199, my lord. But along with our representation, we also relied upon the judgment of this Honorable Court, my lord. Back in 2011-12, my lord, the lordship has held, my lord, that if a joint venture participate in the tender process, my lord, what would be the criteria of getting the credentials?
The question is whether submission of a document
My lord.
subsequent to the bid, last date of bid submission is permissible or not.
My lord, with due respect, my lord, if your lordship sees close 4.5 again for a moment, my lord.
4.5.
Yes, at page 31, my lord. The lordship has read 4.5A, Roman A. Thereafter, your lordship would kindly see note. Qualified similar works may be physically inspected by PWD engineers to ascertain the completion, performance, and quality of works for finalizing technical bids. So, my lord, it is open for the authority, and my lord will see the minutes. There, they don't say that my document is rejected. They have taken into consider that document because in respect of other bidders, your lordship would see they also had joint venture, but no consideration was given in respect of others at page 15. My consideration vis-a-vis the other tenderers is different, my lord.
So come to page 215,
Yes, my lord.
seal number
3.
3 also.
Yes, 3, 4
They submitted the bid document
bid document, but
and joint venture also.
but there the percentage was not there, my lord. But what I say, my lord, my consideration for 90% and 10% was accepted by them, but they say it is from not confirmed with APDCL.
No, in your case, it says their share percentage of joint venture party
Yes,
could not be ascertained from the available submitted document. Right? It is clear that the document submitted with a technical bid,
my lord.
it could not be ascertained. Now, in the meantime,
My
that is after bid
Yes,
submission,
yes.
after bid
lord.
submission, you have willingly submitted,
Yes, yes.
willingly submitted.
Yes, yes.
It is not
It
that
is-
they have called for.
No, no, no. We have submitted. my lord.
Then joint venture agreement between so and so 90% and 10%. But this document is not part of the bid document or whatever.
No, we have not submitted with the bid document. We have submitted the work order, and this is submission as a clarification of our bid
And
document.
this
my
could
lord.
not be accepted for evaluations.
No, my lord will see, but this document is not part of the contract with APDCL.
I don't know that is their understanding, but it is part,
My lord, that is,
perhaps
I am saying, my lord, the
not part
reasoning.
of the bid document.
Reasoning,
Maybe
But if they have-
their understanding may be different.
but that's why I say, my lord. My lord, assuming, my lord, I
That's why
am,
the bidder is technical. So that joint venture document was not part of the bid document, right?
yes, yes,
That is a
Yes,
admitted fact.
that is a
And
fact,
subsequent to bid submission that
my lord,
you submitted that joint venture agreement,
my lord,
which you submitted willingly,
my lord,
right?
my lord,
And it said that document indicated 90% and 10%,
my lord,
right?
my lord.
But this document is not part of
With APDCL, my lord,
that, maybe. And this thus could not be accepted for
so, my lord,
evaluation.
they could have verified this, my lord,
Why they will go for
my lord,
verification?
because under
Just
the,
because of a note.
no, no, yes, my lord, because
That
under,
is their discretion.
my lord will see,
Firstly, technical bid has to be complete in all respects.
my lord, technical bid is completed. Only thing, my lord, there was a clarification. If your lordship would kindly have a look at the judgment I am relying upon, my lord. That has also been annexed, my lord. Page 205.
Okay, judgment to the joint venture percentage to
Para 12,
take to the extent.
Yes, at that time.
That
my
is
lord,
the
it was-
judgment, right?
So, my lord, my submission for your lordship's consideration is, my lord, even if I say tomorrow 90% or 95% or 80%, my lord, authorities are, my lord, have liberty to verify that. And they have verified and they have verified it wrongly,
Liberty is another thing.
my lord.
Exercise of that liberty is another thing. That is within their
No,
domain.
my lord, I understand the
Liberty is one thing,
my lord,
or discretion is one thing,
My lord.
and exercise of that is another thing.
my lord,
And judicial review
my lord.
of exercising the discretion or not to exercise the discretion is another thing,
I bowed up to
Third
your
thing.
lordship's, my lords.
right?
That, my lord, I am not disputing that proposition.
That proposition is settled, right?
No, no, yes, yes. There is
Huh.
only thing, my lord, for my,
And whatever is there that which is essential, which is not essential, which is ancillary, which is not,
my lord,
that should constitutional court should exercise restraint.
my lord, my submission for your lordship's consideration would be, my lord, that the submission that we have made, it was only clarification in nature, my lord, because the work order we have given that has been annexed, it is in the name of joint venture. My lord,
Which is that revised work order.
yes, yes, yes.
Revised work order.
Yes, yes. It's in the name of joint venture itself, my lord.
Yes, Mr.
As Lordship has rightly
And only
stated, my
single bidder has emerged, my lord, and he has also quoted higher than the reserve price, my lord. My quote is much lesser, my lord. I'm just point of
lord,
information.
here, my lord, so far as the 4.5A is concerned, my lord, to satisfy this particular clause, my lord, all bidders, my lord, whoever want to participate will have to provide some documents to my lord, along with the technical documents, a technical bid, so that the, my lord, the authorities can evaluate it. In the present case, my lord, last date of submission of bid was 31/12/2025. Now, my lord, this clarification has been issued furnished by the petitioner only in, my lord, 9/1/26, after the last date. And in that particular clarification, they have annexed this, my lord, joint venture agreement, from which they want to clarify that 90% share was of the petitioner in that particular court, which cannot be accepted because this is not part of the, my lord, bid document, as correctly pointed out by this honorable court. Now, my lord, so far as the note is concerned of 4.5A,
That is regarding genuineness.
Yes, my lord, not regarding percentage, my lord. We'll see the work, my lord, how it was executed.
But with due respect, my lord,
Performance,
it regards
quality and all.
completion, performance.
Yes,
health.
completion,
But it will-
performance,
First,
and
it's it has to be qualified.
Yes.
Similar work has to be qualified.
My lord, no,
Then it may be inspected. May be
Lord,
inspected.
my submission subject to what your lordships hold is, Lord, it's within the domain. Say I have given a certificate of my JB. Lord, they can't, Lord, inquire whether I have completed it properly. What would be my share? That would also be included in that. Because tomorrow it could be, say, if it's 90%, I am saying that it's my 100%. So that
No, that.
domain is there within them.
Inspect or not, may be physically inspected. That is not our concern.
My lord.
Qualified similar work. First, it has to be qualified.
No. Qualified similar.
Note.
No. Qualified similar work means the similar work which I have annexed.
That is followed by may be physically expected.
Yes.
So that is their discussion. Why we should enter into that domain? We are not going to enter into that domain.
What I'm saying is that the tender conditions permit me, Lord, say tomorrow if I have given 90% of my JB, Lord, assuming.
Had the revised work,
my lord,
that was not clear percentage, right?
Yes.
That was part of the bid document.
Yes.
Right. So, like the third one, on that count, same fit. No discrimination. The third bidder from the JV,
is not acceptable.
Percentage stake was not also ascertained on the same count.
My lord.
Right. It is not that you have been
No, I'm
treated discriminatorily.
my contention is not
Like the third bidder.
But
So
my-
on the same count, were done, right? In their case, the joint venture agreement perhaps was the part.
no, my lord, it is also not.
Now, let us see.
My lord.
We are not examining. We are not sitting in appeal,
Yes, my lord.
right? Bidder has submitted the joint venture similar work.
That work means like my certificate.
Percentage not ascertained.
So, my lord, there also there is no agreement. My lord,
So,
in my case,
What wrong?
my lord, in my case,
That we are not willingly submitted, we are not going to do it. What is the wrong they have committed?
my lord,
Constitutionally, in tender jurisprudence.
my lord, my submission for your lordship's consideration would be, my lord, that I must, as a documentary proof, my lord, and annex my completed work that I have submitted, my lord.
To the
Now-
extent that in the joint venture agreement or joint venture work carried out by you, for similar work, your share was to the extent of 90%,
My lord,
right?
my lord.
But that situation was not existing at the time of bid submission.
No, my lord.
At the time of bid submission. I'm not saying that on the date of
No.
evaluation of the
No, with
technical.
due respect, my lord, it was existing, but I did not annex because that joint venture agreement is of 30 December 2019.
Tell me, show me.
Yes.
Anything that permits, which Supreme Court judgment has permitted you, authorized you. Single bench judgment regarding joint venture stake is all right. That is to be followed.
it's just a settled law.
That is
New
settled.
Horizons case is.
So far as this court is concerned, that is settled unless, right?
My lord, page
That's
20.
the earlier judgment which you have said.
Page
But
20.
tell me, by which judgment of the Supreme Court that
First,
this kind of
I'll respond to your lordship's query, my lord. First, lordship would have page 202, my lord.
So first you tell me why we should look into it.
My lord will just
Why we should look into
my lord
it?
will look into, then my lord, I'll answer
No,
it.
I'll not look into it.
Just
First you tell me the first part. You cross the first one.
yes, my lord.
That in what situation
My lord.
a document
My lord.
submitted subsequently
My lord.
beyond the last date of submission of online bid,
My lord.
right? Online perhaps?
Yes.
Online.
Online.
Online bid
Yes.
is to be accepted. When online bid is closed on the last date of submission,
My lord.
thereafter you cannot upload.
My lord.
No document can be uploaded, right? It is closed. the portal is closed.
Hello.
So far as submission of bid is concerned, any further document. Now, show me that bar, how you can cross that bar. That's all.
But my submission would be, my lord, that the document which is,
Ignorance or say lack of awareness
my lord,
can be a ground.
no, my lord, my submission would be in respect of the other bidders, my lords, they have not indicated the percentage of shares. So far as I am concerned, Lord, they have.
You also did
taken-
not.
No. Lord, after my representation, they have considered. That is how on the basis of they say 90% and
That is
20%.
what I am saying, that making them aware
My lord,
after the bid submission,
my lord,
is it a permissible way
my lord.
in tender jurisprudence? That is all I want to say.
Lord, my submission for your lordships consider would be, my lord, the
Show me
representation,
some authority that
representation,
bid can be supplemented. Bid document can be supplemented after submission of bid document. And where it is matter of qualification. The
I understand
point.
what query has fallen from your lordship.
That is what. That's all.
Can I pray your lordship may take it day after tomorrow, my lord, I'll satisfy your.
That's all.
My lord.
That's
I understand, my lord, what has to.
because all are otherwise
Yes,
level
yes.
playing field is gone.
My lord.
If your document is permitted for examination by the bid evaluation committee,
My lord.
then by that central coalfields, everybody has to be kept open because that third bidder is to be,
Yes, he
this
should be given the.
treatment is to be given to you. Then why not the third bidder?
Let I'll answer that. My lord.
If it is that central coalfields,
Yes, the central coal fields, my lord, it says. My lord.
if one thing is to
But
be
I
allowed,
distinguish that.
then
my
all
lord,
these things to be allowed.
My lord.
So if the discretion is not exercised, then it is applicable to all.
I will kindly take it after day after tomorrow. My lord. Yes.
Financial bid has been open or what?
Yes, yes.
Huh?
The last page one.
Last page.
Private respondent has, my lord, he has. come out
And
as-
you took 9 days time. Okay. Now you say that my bid is lower.
There.
No, in one day they have opened it, my lord. It's a matter of record.
It's a.
It's a matter of record.
Somewhere it is said that
No, I'm not going on that, my lord. If I don't,
price is not
no,
the
no, no, my
concern.
lord. If I can't cross this hurdle, my lord, I am out.
Sanctity of the process is there.
Yes, yes, yes.
Okay. I do be. And counsel put a petition. You show me that only.
Yes, yes, my lord, I'll try to.
Sought for listing of the case on Thursday to complete his instruction. For all the respondents, respondent number 1 to
1, 2, 3.
except the last one, I think.
Till
Except
4.
the last one.
1 to 4.
1 to 4, my lord, my friend would
1
appear.
to 4 is.
5.
Deeply above.
We'll examine because
Yes,
this,
yes.
if you can cross the hurdle.
My lord. Deeply above.
Daily list for admission, item 1.
My pleasure, Lordship.
Uh,
Lordship, in this matter, learned senior counsel Mr. M.K. Chaudhary appears, Lordship, but today he has his father's annual Shraddh, Lordship. So that is why he could not come today, Lordship.
I'm for the respondent number 5. I have been
Okay.
informed, my lord.
Mr.
W. Rahman on behalf of
W. Rahman, learned counsel for learned counsel, appearing on behalf of the petitioner, submitted that Mr. M.K. Chaudhary, learned senior counsel, who is leading him, this has some personal difficulty to make submissions today. Full stop.
But can it be fixed on tomorrow, Lordship? Then, Lordship, next week, Lordship, next
That
week,
is
next week,
because
Tuesday.
you have to look into the further code also. Who is for the respondents? You are
I'm for respondent number 5.
Ms. D. Hajorika, Standing Counsel, Revenue Department, for the respondent number 1 to ensure Ms. U. Das, and External Senior Government for the respondent number 4, and Mr.
N. Patiri.
N. Patiri, learned counsel for the respondent number 5 are present. It's submitted that a mention that effect has already been circulated. Place the case on side. The interim order passed earlier shall continue till the next.
Can it be on 17th, Lordship? I'm praying.
We have a calendar also. Like
understand.
you have a calendar,
Yes.
right? We have a calendar also.
Yes, Lord.
So you also see the slots.
Yes, sir.
23-2.
Hello.
2 and 3.
Also, in a tender process, I have been allocated 2 works by the BTC head. Thereafter, I have executed a work and completed a work. Completion certificate has been issued. Thereafter, Lordship, my bill has not been paid. Then I came to know that the executive engineer who was working in Canary division, he issued a short tender for same work and allotted the work to some other person. I have
Who had certified your work? Who had certified your work? Completion certificate?
Executive engineer. Executive engineer.
Not the head of the department.
No. Because it is under the executive engineer division, I have to complete the work. I have to complete.
Yes, the law is full bench is that head of the department. Unless it is certified by the head of the department, it may not be acted upon.
Lordship. Only thing
We
is, Lordship,
normally issue notice thereafter, giving a submission affidavit, thereafter we dispose of. Okay, let us see.
in this particular
Yes,
case,
Mr. Upaidhya.
Lordship, I'm in the contempt petition, Lord.
in this particular case, Lordship, we have
Contempt petition only,
Lordship.
not
I'm
in
the-
the main petition.
Main petition, Lordship, BTC is the main party, Lordship.
Where are they?
So they have filed affidavit also. I have not got a copy filed by the BTC, Lord.
On the last date, who appeared? B. Bora. That was on 30th. BTC. Yes, ready. Huh?
There is an order to file an affidavit.
When?
Earlier to order.
Pleadings have been exchanged.
Bridging his expense, but there is an order of this honorable court that one affidavit should be filed BTC regarding Lordship release of the amount after having the order of this honorable court.
Timing. Today. Okay. Timing. Nine.
Possible for typing, my lord.
Item 6.
My lord, petitioner's counsel is coming, my lord. He just was here.
What is your? Which department?
This is my lord, handloom, my lord.
Leading happening action. Further instruction in the matter.
Yes,
Yes,
ma'am.
any instruction?
I have been.
Let us.
The other day, my lord, the query was put whether we are going for any further.
I am to invent a valid extended. It is to inform this data has not yet decided for further. Is it not contradictory?
My lord,
Huh?
thereby they are not going. That is the thing, they are not going to further.
No, it says the validity of
information-
empanelment was extended up to 50 in July 2026, in accordance with the approval of the state level project committee, right, mind it. As per so-and-so, there is a provision. Further,
I don't know.
so beyond 15 July 2026, that no decision is taken. But we are in February,
We are in February.
still how much month?
4 months.
5 months.
4 months.
4 5 months. Yes. What is the case?
No, here what has happened, my lord, the handloom and textile department, they issued a notice inviting bid. My lord, for empanelment of manufacturers and suppliers for supply of handloom.
Where is that?
That tender lordship will find at page 21, my lord.
Page 21.
Page 21.
Two-bid system,
Two-bid.
procurement or empanelment of manufacturer, supply of handloom.
Suppliers for handloom and handloom accessories.
Available bids are available. Okay.
Now the
This is the bidding document.
bid document.
Ah.
Now the relevant clauses in the tender should be, my lord,
It was
clause Clause 3, my lord, at page 35. Now, I
Clause
participated in
3.
page 35,
35.
35, my lord, clause 3.
1 minute.
I participated in the
Just a minute, just a minute. It was online bid.
online bid, but hard copies were also required to be submitted, my lord. Hard copies were also submitted. Online plus hard copy.
Which page you want to?
Page 35, there are 11 clauses, my lord. I participated in the bid, my lord, bid process, but my technical bid was rejected on the ground that,
Let us see the clause first.
my lord,
Which clause?
clause 3. would be
Clause
relevant.
3,
Clause 3.
qualification of the bidders.
My lord, qualification, eligibility criteria of the bidders, following documentary proof is needed. 3A, manufacturers, suppliers should be a registered manufacturer of handloom and handloom accessories or authorized supplier of the manufacturers of the relevant goods.
You have?
Yes, my lord, I'm a manufacturer. I'm an
Okay.
MSc, my lord. The bidder should state in what capacity she is participating in the bid process as a manufacturer supplier. The bidder, in case of registered under MSME, he should have submitted the up-to-date UDAM registration certificate from the competent authority and clearly mentioned that he is a manufacturer of handloom accessories. I'm an MSME, my lord. Clause
Where is your
B,
certificate? Yeah.
certificate,
Later
my
part.
lord.
Okay, or later part, okay.
Now, clause B, Lordship may skip, my lord,
Average
it's not relevant to us.
financial turnover.
3C is relevant to us, man. The manufacturer supplier should have experience of supply of handloom and handloom accessories of an aggregate value of minimum rupees 10 lakh only during the last 3 financial years.
Why B is not
So my
important?
case has not been rejected on the ground of B, my lord. On the ground of C, I have been rejected. They say that I don't have the experience. May I read out C again, my lord? The manufacturers, suppliers should have experience of supply of handloom and handloom accessories of an aggregate value of minimum rupees 10 lakh only during the last 3 financial years. The supply completion certificate issued by the competent authority should be submitted as proof of experience. Now, Lordship may skip 3D also. 3D is relevant for us. 3E. It says relaxation for micro and small enterprises, MSCs. As per the government policy circular number so and so issued by Office of the Development Commissioner MSME, Ministry of Micro, Small and Medium Enterprises, Government of India, Micro and Small Enterprises MSEs are exempted from prior turnover and experience in all public procurements subject to meeting of quality and technical specification. This clause specifically provides for exemptions to MSEs from having the experience and the turnover thing. So I being an MSc, I'll place that.
This quality and technical specification is related to 3D.
3?
D.
No.
Perhaps. we'll have to exhibit sample after opening of financial bid.
Opening of finance.
That now, let it be clear. Quality and technical specification that is related to 3D.
3D.
Okay.
Now, they had rejected my bid, my lord,
Hmm.
on the ground that the documents which I had produced before them to prove my experience was not in terms of clause 13 point, clause 13 point, just a moment, 13.3p, 13p, my lord,
Page.
page 42. There's a typographical error out here, my lord. It says for a minimum amount of rupees 50 lakhs, so subsequently corrigendum issued, my lord.
Where is that corrigendum?
They have annexed in it in the
Affidavit.
in
Affidavit.
the in the
Admitted ballot.
admitted position and in the
It is to be read as
My lord will find in page number 57,
27.
57 ballot.
57.
For affidavit.
59, page 59 of the writ petition, my lord, it's there. Page 59, annexure G.
Starts from her.
It's a clarification issued, but the
No, no, not 59.
Not 59 ballot. 57,
57.
57 ballot. Annexure.
Minute.
Yes, in the minutes only, my lord, it is there. Second is 13p.
Meaning,
number-
that right hand side column.
Right hand side column, work completion certificate EP.
10 lakh.
I'm
10.
sorry, ma'am.
10 lakh.
10
10
lakh,
lakh.
That is at page 42. It should be read as 10 lakh.
10 lakh.
Okay, this is to be read as 10 lakh. Okay. 13p.
13p.
Hmm.
Sorry, my lord. 59 was my representation, my lord.
Hmm.
Now, this 13p is directly related to 3C, my lord, regarding the experience thing. 13p C, 13p says
C.
3C.
C. 1 minute. Please.
To prove the
3C is it?
page 35, my lord.
Okay.
To prove the experience, my lord, work completion certificate for an amount of rupees 10 lakhs have to be submitted. I had submitted, but it was not up to the mark, my lord. It was less than 10 lakhs.
Hmm.
So my case before your lordship is that in terms of clause 3E, I being an MSc, I was exempted from having the turnover and experience. And as such, my technical bid would not have been rejected on that ground. And similarly situated persons, respond number 8 and 9 herein, have already been given the exemption with regard to experience, my lord. If I may place those documents, my lord, they have also, my lord, annex.
Let us see your minute technical bid rejection.
Technical bid
Region.
rejection, my lord. Set page. It starts from page 53.
One
The
minute. Final
annexure E.
revelation.
Lordship may turn to page 54
1 minute.
at serial number 15.
One round, 13p.
Just got it. So it says, my lord, documents submitted but not in conformity as per clause 13p. Now, my lord, if I may take your lordships.
Then what happens further proceeding? Let us see.
Thereafter, my lord, the empanelment notification was issued, my lord. There were other writ petitions also filed before this honorable court challenging.
So by that, didn't have qualified. 16 are disqualified. Following resolution. And financial bid, there was a financial bid. Financial bid.
Thereafter, my lord,
When financial bid opened,
that my learned friend would be able to say, my lord, but thereafter, my lord, they had issued the empanelment notification.
it is 28, 18-1. Okay.
That your lordship,
57 is before 53, I think.
57 is?
That was on 18-1-2024. 53 is 22nd February 2024.
50.
I thought that it is date-wise. No, it is not date-wise.
22nd February, and this is 18-1. This corrigendum one was issued prior to opening of the tender.
Right. You have submitted the document, which is of 18-1, subsequent to
Subsequent.
February document.
No, I was not.
January document is subsequent to February document. That is what I said.
I was not the.
Normally, we.
No, I understand, my lord. I was not. I apologize, my lord. I was not the original counsel in this case, much. Had come in subsequently, my.
Yes, what is your ground? What is your ground? Miss, what is your ground?
My lord, 13P. He did not, my lord, have that 10
Where is your
lakhs.
certificate?
My certificate, lordship will find that
He has some 3 lakhs. He could.
No. First, let us see.
at page
Document
93.
93.
93.
It was not part of the original
Yes,
petition.
No.
Yeah, it was there, my lord. But
No,
this is more
Not
like
in the writ.
in the writ also, my lord.
Part of the bid document.
Yes.
Part of the bid document.
Yes. Obviously, my lord. Otherwise, they would have rejected my tender on that ground itself.
93.
No, sometimes it happens. I claim to be MSME, but I did not
No, that
submit the
no,
certificate.
absolutely not.
The same region can be attributed as recorded.
No. I'm sure, my lord.
My
It's
lord,
not the ground. Because on that ground,
they-
another
what-
tender was rejected, my
We'll
lord.
look into there. Now let us see your 93 micro classic bid document, 11 January classic. You are what kind of unit you are? Micro, small?
My lord,
Where is that?
MSC, my lord, micro and small enterprise.
Where?
Micro, small and medium. My lord, at the top, my lord, micro. Enterprise type, micro. Type of enterprise, my lord.
And what is their
Now,
stand?
may I just clarify one? My lord, pertaining to the same tender process, my lord, other writ petitions were also filed. My lord, those two writ petitions were dismissed, 2 were allowed, my lord. My case is squarely covered by those writ petitions which were allowed, my lord.
No, what is their stand?
The stand is that, my lord, in the affidavit, after having submitted the proof of experience, my right to claim the exemption was waived, my lord. That is one ground. The second ground is that in terms of another ON issued by the government of India, my lord, this exemption is not permissible. Both those grounds were taken into consideration by this honorable court in the other writ petitions and have been rejected.
Well, let us see their stand.
In the in their affidavit in opposition, my lord, they have stated this.
13.
In para 8, my lord, that is no, para 7.
Para 7, my lord.
Para 7, my lord. This is
So how we have dealt with Uddam certificate?
That was,
No, in the affidavit.
My lord, we did not, for the
First
certificate,
three
my lord, we,
further, it is not entitled so and so as.
my lord, this Uddam certificate, this was not a part of the writ petition. So we did not,
No, but main issue is whether it was part of the bidding document.
that,
Ah.
that I have to take into course.
They have
This is-
supplemented it by reply.
it's
It
a
has
reply.
been brought on record.
my lord, if
What is this notification they are referring to? Signature line.
just, if I may
How
just,
can it be that Mr. Dhar
My lord,
annexer 1 to the affidavit in opposition? Is that what is certificate? Some you have referred to some government, government of India. But without enclosing it.
they have not enclosed that poem, my lord, that was enclosed in the earlier round of litigation. That-
there are, these are all tag matters, my lord. So in another writ petition.
That ground was already dealt with, my lord, by this honorable court. If I may just place the judgment, my lord.
Then on reading of section 3E, clause 3, it is eminently clear. If Uddam certificate has been there, then the experience and the turnover are not to be considered.
No, that is there, my lord. But this court has already looked into, my lord.
Paragraph
So
15
that-
and 23 of
that
the
is why, my
judgment.
lord, we did not go for an appeal also. 2 writ petitions allowed.
Paragraph 15.
So I cannot, my lord, today I cannot go the other way around also, my lord.
15
There
and
is a,
23 will clarify the issue. Both the grounds have been taken care of. Whatever grounds they have urged. 15 and 23.
we have, my lord, accepted it, and we have given those 2 writ petitioners also empanelment thereafter. So I cannot, my lord, now for him, I cannot go against. The same ground, 2 other writ petitioners were allowed.
The next stage is for qualification of your financial bid.
Financial bill. My lord, that is.
But empanelment is up to 15 July. Whatever is survive, that is only for that.
For that period.
All that period, my lord.
Okay.
Just, if I may just point out one thing, my lord, the financial bid would not be relevant at all because whoever is the lowest bidder, at that rate, all will have to supply, my lord. That provision is on.
Whatever this
yes,
is a
madam.
2-bid system, your final bid is not yet obtained,
Absolutely.
right? So it has to be examined.
It has to be.
Thereafter, it is BOQ, L1 rate, that those are will come, but that consideration is to be given.
Absolutely.
That we cannot direct that put the seal financial bid as in the seal condition, give him empanelment. No, that is not the.
No, not at all.
It
Just try to
has to go
point
through
out.
the process, man.
It has to go through the process. You have to pass that.
Sure.
Right. Okay, take your seat. Mr. Goswami, previous item. Oh, nobody was there from neither side. Okay, after some time. This writ petition. Article 226 of the Constitution preferred by the petitioner. Assailing a decision taken by the Technical Evaluation Committee on 22/02/2024. In connection with the bidding process initiated by a tender notice dated 11/1/2024. Full stop. The Technical Evaluation Committee, by its decision dated 22/2/2024, had inter alia disqualified the petitioner on the ground that the technical bid submitted by the petitioner was not conformity with clause 13 within bracket small p of the bidding document. Full stop. Para. By an e-tender notice published by the respondent number 2, bids were invited into bid system within bracket technical bid and financial bid. Page 21 of us. Through e-procurement system for empanelment of manufacturers / suppliers for supply of handloom and handloom accessories to the beneficiaries under various schemes of the Government of India and the Government of Assam, implemented by the Directorate of Handloom and Textile, Assam. Full stop. In the bidding document, the timeline of submission of bid was mentioned. Full stop. And the manufacturers / suppliers were directed to submit their technical and financial bids online as per the time schedule mentioned. Stop. Para. The petitioner has claimed that he deals in production. He is in the business of production and supply of handloom and handloom accessories. And he has experience of supplying those to various government and semi-government agencies, and has gathered experience in the said field. Full stop. The petition has further stated that it has been registered as a micro enterprise with the Ministry of Micro, within bracket, comma, small and medium enterprises, comma, Government of India. And it has a Uddam registration certificate to that effect, with validity as on the date of the e-bid notice, as well as on the date of submission of, last date of submission of the bid. Close to. The Uddam certificate, registration certificate issued the petitioner had listed the products which the petitioner used dealing, and the products mentioned in the Uddam registration certificate are some of the items for which empanelment has been sought by the e-bid notice post of para. A total of 26 number of bidders participated in the bidding process initiated by the e-bid notice. E-bid notice dated 11/1/2024. Full stop. The Technical Evaluation Committee initially technical line two. Down, huh? The Technical Evaluation Committee. Oh, no, Robo. A pre-bid meeting was held on 18/1/2024. And the chain was aired by the respondent number 2. So after discussion, after due deliberation, after deliberation on the issues with all the manufacturers stroke suppliers, it was recommended that the work completion certificate for a minimum amount of rupees 10 lakh only during the last 3 financial years from the competent authority as experience of supply of looms and accessories in different department of central government stroke state government should be submitted. Itur agot pera eta hobo. Itur ei pera to. Ar agot eta pera. in the EBID notice and in the bidding document to the EBID notice, comma, the qualification stroke eligibility criteria of the bidders and the documentary proof needed for the purpose of qualification or eligibility criteria were laid down in clause 3 of clause 3 thereof. So stop for ready reference, comma, clause 3 of the bidding document are reproduced herein below. Page 35. Page 4. 36, 35, 36. Bishop, 10 lakh to prepare. The Technical Evaluation Committee, for the purpose of evaluation of the technical bids of the bidders, held this meeting on 22/02/2024. Full stop. A total of 26 number of bidders participated in the bidding process. Full stop. The technical bids of 26 number of bidders were opened and evaluated by the Technical Evaluation Committee on 22/02/2000. Full stop. Upon the evaluation, comma, the Technical Evaluation Committee found that held 10 number of bidders as qualified and 60 number of bidders declared as disqualified. Full stop. The petitioner was one of the bidders disqualified at the technical bid evaluation stage. Full stop. The technical evaluation committee, in its minutes recorded on 22/02/2024, had further decided that the financial bids of only the 10 number of technically qualified bidders would be opened on 4/3/2024. Full stop. Para. Agreed by the region shown for disqualification of his technical bid. The petitioner submitted a representation before the response number 2 on 26/2/2024. Full stop. The petitioner represented that as per clause for an MSE unit, there was no requirement of meeting the turnover criteria and the experience criteria as mentioned in clause 3C. Clause 3 clauses 3A, 3B, and 3C of the bidding document. Full stop. As no response was received from the respondent number 2 on the said representation, the petition is good. The present rate petition. Full stop. Para. Mr. Sharma Learned, I have heard Mr. P. Sharma Learned, counsel for the petitioner, and Mr. R. Dhar Learned, standing counsel, handloom and textile. Department. Government of Assam. For the respondent number 1 and 2. Full stop. Though the respondent number all are served.
That appeared also, but they then on the last occasion they were absent.
So the respondent number 3 to 12 were duly served with the notices. Of this component. Comma 7 except the respondent number 6 and 10. The other respondents, EIJ, Pagira, Gonidio, choose not to appear and contest the present proceeding. Full stop. Para, Mr. Sharma, Lieutenant Counsel, the petition has submitted that from a reading of clause 3E of the bidding document, it is evidently clear that an MSc unit like the petitioner who is a small micro unit need not have to meet the turnover criteria, turnover and the experience criteria. In the bidding process initiated for the e-bid notice, full stop, and as such, full stop. The region shown for disqualification of the technical bid of the petition by resorting to clause 13P of the bidding document is clearly arbitrary. Full stop. He has further submitted that in case of two similarly situated bidders, this court has already granted, has already held that by virtue of clause 3E of the e-bid notice and the bidding documents, the MSEs were exempt from prior turnover and experience in all public procurements, more particularly, in the bidding process under reference in view of incorporation of the clause 3E on the basis of the government of on the basis of the government policy circular dated 10/3/2016. Post of Kara. Ministers for Learned Council, Planning Council, Employment External Department preparing for the one has supported the decision of the Technical Evaluation Committee stating that as per clause 13, small p, comma, a work completion certificate meeting the criteria was a requirement. So insofar as the petition is concerned, the petitioner has submitted a work completion certificate, which was much below the prescribed criteria. Yes, however, fairly submitted case of two similarly situated bidders, this court has held that clause T small of the bidding document exempts an MAC unit from meeting the turnover and experience criteria. Post of para. It is from a reading of clause A. It is no, as per clause 3A, a bidder who claims to be a manufacturer, supplier, should be a registered manufacturer of handloom and accessories or authorized supplier or the manufacturers of the relevant goods. Full stop. The bidders, in case a bidder, in case he is registered under the MSME, Government of India, then he must submit an up-to-date Uddam certificate from the competent authority and wherein there should be clear mention that he is a manufacturer of handloom and accessories. There is admittedly, the petitioner was in possession of a Uddam registration certificate having validity. Uddam registration certificate as a micro enterprise having validity. On the last date of submission of the bid. At the time of submission, last date of submission of the bid. Post of in the Uddam registration certificate, certain products. The products are listed in respect of which the petitioner the products which the petitioner deals in are listed. Post of para. As per clause B, clause 3C, and the subsequent decision taken in the pre-bid meeting on 11/1/2024, a bidder as a manufacturer stroke supplier should have experience of supply of handloom and handloom accessories of an aggregated value of minimum 10 lakh during the last 3 financial years, and a supply completion certificate issued by the competent authority as a proof of experience had to be part of the technical bid of the bidder. As per clause 3B, comma, the average annual financial turnover during the last 3 years, that is, comma, 2020 plus 2021, 2021 plus 2022, and 2000 plus 2000 should not be less than rupees 50 lakhs. And in audited stroke certified balance sheet with IT return files for the years concerned should be a part of the technical bid of the bidder. Full stop. However, comma, as per clause 3E, comma, a micro, micro and small enterprises, within bracket MSCs, were exempted from the either from the prior turnover criteria. I don't know, both from the prior turnover criteria and the experience criteria. In the empanelment process under reference, subject to meeting quality and technical specifications. For the purpose of exemption, comma, a bidder claiming exemption, for the purpose of, a bidder claiming exemption as an MSC unit was required to submit an up-to-date copy of the certificate of registration for micro or small enterprises, within bracket Uddam registration certificate issued by the Ministry of Micro, MSME, comma, Government of India. Full stop. The bidders, a bidder who is a genuine manufacturer of handlooms is or was also required to mention clearly no, I do line cut off. The bidders must be genuine manufacturers of handloom, and there should be clear mention to that effect in the Uddam registration certificate. Para. In clause 13, comma, the documents required to be submitted in the technical bid online were mentioned, with the condition that in case any of the documents were not submitted either with the hard copy or online, the bid would be rejected. In clause 13p, comma, it was mentioned that a work completion certificate for minimum amount of rupees 10 lakh only during last 3 financial years from the competent authority as experience of supply of looms and accessories in different departments of central government stroke state government should be submitted. Full stop. The petitioner had submitted in support of his experience. Where is your document?
93, my
93. That is Uddam. In support of submitted few experience certificates. For the purpose of establishing that it had a good track record. Full stop. The documents submitted in support of the petitioner's experience did not meet the threshold criteria of work completion to the extent of 10 lakh. Full stop. The respondent authorities, the technical evaluation committee, had, however, taken note of the said fact and in the affidavit in opposition made a mention of the same. So, in WBC number 4290/2024, within bracket, as such Doibuki Enterprise Canada versus the state of Assam and others, bracket close, decided on 4/12/2024, the same clauses of the bidding document, that is clause 3 and clause 13 within bracket P of the as involved herein came for consideration. The question that arose therein as to whether an MSc in view of clause 13 can be held to be exempted from meeting the turnover criteria and the experience criteria. If the MSc unit is in possession of a valid Uddam registration certificate, upon consideration, the coordinate bench has held that though clause 3B and clause and they held that MSCs are under clause 3 on the bidding document from submitting average annual turnover in terms of clause 3B. It has been held, it has been observed that even if a participant MSc, even if a participant MSc participant bidder MSc would submit or would not submit documents pertaining to turnover, they being exempt from having any prior turnover or experience in all public procurements, the bids submitted by the MSs with or without turnover, would have to be considered to be valid, subject to the MSs meeting the quality and technical specifications and meeting up-to-date certificate of registration, Uddam registration certificate, stroke UDIN number for the MSc. Full stop. Non-submission of annual financial turnover certificate, as well as work completion certificate meeting the threshold of rupees 10 lakh cannot be a ground to disqualify such an MSc bidders technical bid, as they would have to be treated as additional documents which are not required for scrutiny in view of clause 13, clause 3E. It has been held that in view of the exemption clause under 3E, an MSc bidder is not required to submit any document as per clause 13, in bracket P of the bidding document. Having examined the relevant clauses, and in view of the decision made above with the regions assigned and the decision of the coding defense in Gauhati Enterprise Supra, this code is of the clear view that the region assigned for disqualifying the petition at the technical bid evaluation stage, resorting to clause 13, is clearly arbitrary and therefore cannot stand as developed. It is therefore the of the technical evaluation declare the technical bid of the petition is qualified. It's meeting it satisfied. The as per the EBID notice, the EBID notice, it was mentioned that the technical bid should be opened by the tender evaluation committee. Full stop. Empanelment of manufacturers stroke suppliers for supply of loom and accessories would be considered from the qualified technical bidders. Full stop. The financial bid would be opened by the technical evaluation committee. Financial bids of only those bidders, only the technically qualified bidders would be opened by the tender evaluation committee. Full stop. The evaluation such evaluation would be done for each item in the price schedule BOQ separately item wise. Full stop. What is the period? 1 year.
The first.
It was there.
There, man.
I have seen. I'll come back. I'll come back to find out.
Hello.
1 year.
Page 25.
As per clause 1G of the bidding document, comma, the empanelment list and rate of items would be valid for a minimum of 1 year, with a provision for extending the same for second year or more by the Directorate of Handloom and Textile, Assam, subject to consent of the suppliers and satisfactory performance and receipt of permission from state level purchase committee, right? SLPC means state level purchase committee. SLPC means SLPC stroke government.
I'm not sure, man.
Full stop. The
State level.
the participant bidders
State level procurement committee.
procurement committee. The bidders who were found qualified in both the stages of bidders who were declared qualified after opening of the financial bids were empaneled by the list of bidders were notified by the Directorate of Handloom and Textile, Government of Assam on 15 July 2024. Post of Mr. Dhor, Learned Standing Council, Health and Family Welfare. Oh, sorry, Handloom and Textile Department has submitted on instruction received via an office letter dated number so dated 7 February 2026. Has submitted that the validity of empanelment of manufacturers to suppliers has been extended up to 15/7/2026. As per an order dated 15/7/2024, with approval of the state level project committee SLPC. He has further submitted that the Directorate has not yet decided for further extension of the existing empanelment of suppliers beyond the current validity period. Full stop. As the validity of empanelment is up to 15/7/2026, the respondent authorities, more particularly, the Technical Evaluation Committee, shall now open the financial bid of the petitioner within a period of 15 days from the date of submission of a certified copy of this order. To stop if upon opening of the financial bid of the petitioner, the petitioner is found to have met the criteria set forth in the bidding document uh, 10, appropriate decision should be taken immediately thereafter for empanelment of the petitioner. With the above observation, direction, and the petition, and allowed to the extent indicated. There shall, however, be no order to, empanelment of it, till the validity of the empanelment list. That is 15/7. That is 15/7/2000. Consideration after financial bid. Ask them. It's out of-
Yes, my lord. I think this matter may.
Mr. Sahewala, I think.
Item number 5.
Yes.
Sahewala.
Yes, he's busy somewhere possibly.
He's on legs. In code 25, my lord, may kindly take it up after some time.
And may I pray that the lordship may have it after something.
After?
After, I mean, lord, it may be adjourned subject to your lordship convenience.
Okay. When you are available?
After 4 weeks.
4 weeks. March?
March.
March. Give a convenient date.
After 7th March.
7 March.
Because I'll have to be away for a while.
What to do? Take your instruction. We relieve Mr. Goswami. Ms. Choudhury will be here. Find out a date in March, after 7 March. Right?
Yes, Lord.
Okay. Ms. Choudhury will be there. We'll fix it. Any interim order operating? Okay.
Supplementary list. Item number 17.
लिखित हो जो P.K. Goswami, Lion Senior Counsel, estate by Ms. P. Choudhury. Records. Matter today. Human number 17. Okay. Yes, you got.
Lordship, I got.
Okay. So as the record, just I'll have a glance.
Lordship.
I'll have a glance and I'll pass the order. He did not submit. He did not submit.
He did not submit. Like Marathon.
14-2.
14.
14-2. Into 14/2022, right? It was published in Assam Tribune.
Lordship. Assamese newspaper is also.
Minimum tender. Revenue up to months. Divide production 23,43,000. 23,43,600. Divided by 6. $23,43,600 divided by 6. So he is meeting the criteria as per the calculation sheet. 3,90,000 per year. So 3,88,000 is the minimum revenue. So we cannot examine that aspect that his bid was below. That is what the calculation is. Okay, we'll pass the order by tomorrow. I'll keep this record. You get it tomorrow. I'll record Tapadar's name since he made the submission.
His junior is there.
No. In the main order.
Oh, yes, Lord. Highly obliged. Highly obliged, Lord.
Most obliged.
And Miss Eudas, 5.
I mean, when
Oh, it will forward.
may I submit one thing, Lordship?
Yes.
Lordship, I have consulted the matter with my client also. In this particular case, we have filed with petition telling the work order issued to the private respondent after completion of the work by the earlier executive engineer. Though my work order was issued by the consult head, but thereafter they have certificate, completion certificate. Thereafter, Lordship, he has issued a separate work getting tender and issued a work order to two different persons. They were also party in this particular case. Thereafter, this court passed an interim order not to release the amount in favor of them. And this order has been violated by them. And immediately thereafter, also, the order was communicated. After communication of the order, also, they have released the amount. They have taken a stand in their affidavit stating that the clerk who has received the order left the office after keeping the order in the prior. That is why the executives are not aware regarding the order passed by this honorable court. We have filed reply to that effect that I have communicated the order to the executive engineer also. Executive engineer informed me to give the copy to the receive section. That is why receive section has received. But in this particular case, ultimately, Lordship, in its repetition, I have to file a civil suit because money has already been released in favor of the private respondent number 4 and 5. So
for that claim is concerned, your claim for the entire amount of the bid value or completed works as per the completion certificate. And since there is some dispute, so I think that is the civil.
I have instructed my client that with liberty or Lordship may give a liberty to file a civil suit for the final amount. And contempt petition, Lordship to decide whether it is a contempt or not. That is my case. Contempt he is appearing.
In fact, I filed my affidavit in the contempt petition, Lordship. And I have narrated what is the reason, Lordship, how I could not find Lordship got the order from passed by the Honorable Court, Lordship, in paragraph 4 of my affidavit, Lordship.
What is the order?
Lordship.
Which is the order?
Order is at page, Lordship will find the petition at page 15.
In the contempt petition?
Page 15. Portion, page 16. Lordship, they have taken a stand at para 4 of their affidavit. Lordship will find.
Paragraph 4, 5, Lordship.
May I read, Lordship, para 4?
Called by executive engineer.
Executive engineer.
Executive. Lordship, one thing, Lordship, he's already retired also, Lordship.
That
This
is not a
person.
matter.
No. Just for the fact, Lordship.
Deponent beg to state that though the order that a demand was communicated to the office on 6/6/2022, but deponent was not aware of the said order till 27/6/2022. In the meantime, payment has been released. And respondent was 6/7. Subsequently, on inquiry, deponent came to know the order dated 27/5/2022 passed by this honorable court was received by Timothy Honorary Boro, Junior Assistant, Paneri Kalayagan Division on 6/6/2022. But she, instead of bringing the notice to the deponent, kept the file, which is not even within the knowledge of the head of the assistant of the division. And they have issued show cause notice to the clerk also, according to them. But I have filed a reply to that effect that I have communicated the all office know all these things, orders. And after knowing the facts also, they have not taken any steps, issuing notice to return the amount. No steps has been taken.
Page 20 is the so cause to the Lordship concerned delicacy.
So what decision was taken ultimately?
Lordship, a so cause notice was issued.
It is just a show or what?
Lordship, in fact, Lordship, this is the fact, Lordship. As a
No,
my
fact that
instruction.
show cause notice, and
Lordship.
what is the
Then,
logical
Lordship,
conclusion?
the so cause reply, Lordship, is
Whether it is accepted or not accepted.
so cause reply is 29, page 29.
Reply is submitted.
Lordship,
That
Lordship.
is not the end of the matter.
Lordship, Lordship,
That is not the end.
Lordship.
That either should be accepted or not accepted. Right. And secondly, the violation was done.
Lordship, there is.
So what further action was?
In the meantime, Lordship, the petitioner, the contender, Lordship, was transferred from that Lordship particular different Lordship place, Lordship. So,
but that
the
continue.
Lordship contempt is continue.
Contempt would continue.
Lordship contempt would continue.
So what action you have taken for recovery?
So that instruction, Lordship, today I instruction, Lordship.
Violation was complete.
Lordship.
If you show bona fide in recovery, then only you can say that yes, your effort is at least endeavor is bona fide.
That's it.
What action you have taken? This was in 27 August 2023.
Lordship.
That's 10. That will not exempt this deponent. He was there on 27th August 2023. He was 53. So he's 55 now.
No, Lordship.
This Sadhan Burman,
Retired lordship, now retired lord.
how can be? He is
Probably-
sworn in as 53 years.
Wrongly, maybe.
How can it be? Show us his retirement.
Lordship,
Is it not?
I can show his.
Only thing is, Lordship, there are lots of irregularities in this department at the relevant time. Already FIR has been filed against them, and ultimately he has surrendered because the police
This
has
man was arrested.
arrested.
No,
This court-
not this man, lordship.
This court has not
My
granted
friend is
anticipatory
talking
bail
about
also.
lordship, another person lordship, and the earlier incumbent lordship. My friend is lordship, talking about the earlier incumbent lordship. His name is
Anticipatory bail was applied, that was also rejected.
not this man lordship, not this
Well,
person.
Sadhan Burman, Sadhan.
This is Southern Burman lordship.
This notice was issued in this case when
This is Satyaram Kolita at the relevant time. Satyaram Kolita was
this
the
man was
executive engineer.
Satyaram Kolita is not a party here, lordship.
He has not released. Have released.
Sadhan Burman. Notice was issued on 29 2020. What action you have taken to comply with the direction interim order, even if it is interim order? That was last was in 2022, 1/7/2022. Page 29.
Lordship. It's a 22, 1/7/20.
So a decision is to be taken on it. Whether any decision was taken. If it is not taken, then it appears to be a contempt.
Lordship, I'll take that instruction.
It appears primacy to be a contempt. It is a serious jurisdiction. You have to draw up a contempt proceeding first. We have to be asserting. Just give his stand. He has not retired. Sadhar Burma cannot retire.
Lordship, Lordship, it is my fault.
You have
Lordship,
submitted the affidavit.
I have submitted my
You put his age as 53.
That may be
The person retires in 60 years.
Lordship, he is retired in 25, Lordship. No, October 25, Lordship. 2025.
Place the correct facts.
Lordship, this is the correct fact, Lordship.
This is not.
I may be allowed
the
to
way.
correct, Lordship. In fact,
Now,
Lordship,
after declaring his as 53, now you cannot say in 2026 that he has retired.
Lordship, in fact, he is retired. This is wrong. Lordship, maybe Lordship, typical error, Lordship.
Not typography, it is handwritten error. I can understand type AS 53 instead of 58. But here somebody has written hand, either by Sadhan Burma or by Upadhyay.
He is retired, Lordship.
Or by the clerk after getting
Maybe
informed.
Lordship by the
You place it.
Lordship.
Correct facts. One
Lordship.
decision
Lordship.
has been taken. We may drop.
Lordship.
If it is possible to drop, we may drop proceeding. Let him verify by way of an affidavit what further action he had taken. The contender has respondent had taken subsequent to submission of the reply by the to the show cause notice replied by the employee.
Lordship.
But make it clear.
Lordship.
And he has to do it hurriedly. Not that he'll take his own time. But Mr. S. Contempt. Learned Counsel for the petitioner, Mr. N. Upadhyay, Learned Counsel appearing. Respondent. So, where are this contempt petition? Referred alleging deliberate violation of an interim order dated a direction made in an interim order dated
27/5/2022.
27/5/2022, passed in WBC number 35,000. The direction was to the effect that till the returnable date, that is, 27/6/2022 2022, comma, no payment should be released to the respondent number 6 and 7 in respect of the contract work under reference. Respondent number 6 and 7 party respondent number 6 and 7 implicated in the writ petition in respect of the contract work under reference. Full stop. Despite the petitioner has alleged that despite the said direction, comma, when the money was released, the amount was released
in the meantime,
in favor of the respondent number 6 and 7 on
it-
on prior to 27/6/2022.
No.
Full stop. The petitioner has further stated that the order dated 27/5/2022 was immediately brought to the notice of the respondent on 6/6/2022. Full stop. The respondent has mentioned in the affidavit in opposition that as soon as the direction made in the order dated 27/5/2022 was due to his knowledge on 6/6/2020, to his knowledge, comma, he made an inquiry and found out that a junior assistant in his office kept the order to herself without bringing it to the notice of the respondent, and therefore, comma, a so-called notice was issued to the said junior assistant on 27/6/2022. Full stop. In response to the so-called notice, comma, the junior assistant submitted a reply on 1/7/2022. The affidavit in opposition of the affidavit of the respondent is silent and to on the aspect as to what further steps were taken after submission of the reply from the junior assistant. So stop as to establish his bona fide, comma, the respondent is, as it appears, that to establish his ID, comma, the proceeding initiated by the broker's notice dated 27/6/2022 was required to be brought to its logical conclusion. But on the said aspect, the affidavit in opposition, comma, filed on 21 and 27 on 8/2023, comma, is silent. Para Mr. Whitehead. Learned counsel for the respondent shall bring
I'll file an additional
is
affidavit. Lordship.
required is has sought for a week's time.
Lordship, 2 weeks, Lordship. Lordship, he is now retired person, Lordship. I'll have to contact him, Lordship. 2 weeks, Lordship.
Shall has sought for time till 2 weeks of it to bring the relevant facts, subsequent relevant facts in the form of an affidavit.
Lordship,
Yes,
obliged.
let me continue. Steps taken regarding recovery them also, because order.
Also, the said affidavit shall also address the aspects regarding the steps taken for recovery of the amount by the office of the respondent from the concerned person who had received the amount in violation of a direction made in the order dated 27/5/2000. Whatever happens, but this kind of officers should be
Lordship,
cautioned.
Lordship.
But maybe the outcome it is a different thing within contempt jurisdiction, but something has to be done.
Yes, some strictures, Lord.
Place the case on. We keep the repetition pending then, or what?
Petition, Lordship, as per my knowledge, Lordship, we have to file a civil suit.
Right,
Lordship
because
have to
there
give
are
a liberty.
contentious issues.
Lordship,
All these cannot be gone into repetition.
Lordship, in the writ petition. We have to file a civil suit. Lordship have to allow me because the limitation has expired. Section 14.
Yes, we can only
No,
observe
Section 14 or
the time period spent in this
post litigation.
that can be
excluded.
That can be
excluded.
What do you say?
Section 14.
Lordship, okay.
On the next day, we will decide.
Obliged.
Obliged, Lord.
For orders, item 8.
The repetition as sought for by Mr. Goswami, petitioner, counsel for petition, and Mr. Anupaidal, and standing of the Irrigation Department, leaves the case on so and so along with the contempt.
Lordship, in this case, Lordship, contempt, Lordship, will find the order at page 13, Lordship, whereby this court has directed to examine the pending material bills. And if any outstanding found,
Page.
Starts from page 11, relevant portion, Lordship will find at page 13. Paragraph 5. To re-verify the list of pending material bills. Relation to the claim that is serial number. If upon verification it is found that petitioner is entitled to some outstanding, the admitted liability should be paid by the respondent. And the verification was done by the commissioner. Lordship,
where is that?
Lordship find a letter by which he has undertaken before this court to comply this order. Lordship will find that order, Lordship 21/6/2025.
Before this court?
Yes, Lordship.
1 minute. There are many.
Because tag mark. Lordship find the order dated 23/6/2025 of this court. 23rd June order, Lord. It has been recorded.
There is a joint verification report or what? That is the one.
Regarding contempt case, Lordship is a letter of the Commissioner of Panchayat and Rural Development, order letter dated 21/6/2025, whereby Lordship.
21/6.
Lordship.
21/6.
Yes, Lordship.
21/6.
Whereby Lordship, Commissioner has.
To the district commissioner. The district commission. Let me read it.
Lordship, last paragraph, whereby he has directed the Commissioner to comply this order and submit compliance report.
Now, what is the admissibility?
Admissibility, Lordship. Will
Where is
find,
that admissibility?
That Lordship, paragraph, Lordship, third paragraph in the first page, Lordship. Moreover, the Chief Executive Officer, Lakhimpur, had
Moreover, Chief
submitted a
Executive
report highlighted and mentioned that
submitted
the
a
working
report.
estimate around
Very
is 25,22,533. This is the amount, Lord. 25,22,000. That has not been paid, Lord.
Yes.
I'm appearing for the respondent number 3, Madam.
Who is that number 3?
He's the BDO, he's the payment authority. He's not making the payment.
Here, my lord, I have annexed the order, my lord, at page 100, my lord, whereby page 100, annexure A1 of my affidavit. Here, my lord, the Commissioner, Panchayat and Rural Development.
100.
100.
This report is by whom? Commission.
By the Commissioner, my lord, that is, he, my lord, deputed, my lord, the officers to my lord, ascertain the actual volume of art filling done in the scheme. So, my lord, in that they have, my lord, the inquiry report has been submitted, my lord, after this verification, my lord. 101 will be the next page, my lord, the following page. And after my lord, verification, my lord, by all the officers, and they have calculated after, my lord, the verification, my lord, it has come to the, my lord, the page 105 is the, my lord, 105 may be looked into, my lord. That here, my lord, after calculation, my lord, it comes to 9,54,850 rupees, my lord. After physical verification of the, my lord, art filling, my lord. Commissioner, PNRD is the, my lord, competent authority as per Tamsir Ali, my lord. In the paragraph 4 of the judgment also it is clearly mentioned. Technical verification was done by all the technical.
Inquiry report.
Yes, my lord. Inquiry, because art filling, my lord, to get the, my lord, proper evaluation of the art filling, my lord, the technical verification has been done.
This
my lord.
report of Chief Executive Officer.
My lord, because
This report.
prediction,
This report, page 105.
yes, ma'am.
whatever he says that it was forwarded to the commissioner
my lord,
on 2/9/2025.
my lord,
That according to technical verification,
my lord.
5,54,850.
Yes, my, yes, my,
Admission amount has been assessed.
yes, my.
So that is the say.
Admissible amount, my.
Then
That has been paid, my.
paid.
No, no, but even there also not paid.
Paid, my lord.
No,
This
no,
is
no.
the correct statement, my lord.
Out of that
If
only
it
seven
says-
lakh.
No, my lord. If he says, my lord, this lordship may be. Sorry, my lord, both side print has been taken, my lord.
Oh, it's okay.
Lordship may be pleased to see the next page, my lord. If he deny this, my lord, quote, then my lord, let him deny it, my lord.
Colioni.
Because lordship, what he is taking, my lord, a petitioner is taking advantage of the, my lord, statement 106 of my affidavit. There, my lord, at the time of filing of the my affidavit, that was not clear due to some technical problem. The amount related 1,61,000.
Serial number 5.
5, my lord. My lord, lordship will find that page in my, yes,
Okay,
my.
total 9,54,000 according to this.
Yes, my lord.
in-
Entire amount has been
In,
paid.
in,
What? What?
5 FTO.
Yes, my lord. What happened, my lord, lordship?
In 5 FTO.
Yes, my lord. Yes. What my
What is FTO?
lordship FTO number 0.
What
This
is
number.
full form of FTO?
Fine,
Fund
it's,
transfer or what?
my lord, something will be this.
Something related to fund.
But my lord,
All are Colioni, yes.
yes, my lord, lordship. What the petitioner is taking advantage of that. Lordship will find page 106 of my affidavit. There, my lord, at the time of filing of my affidavit, lordship may be pleased to peruse 106, my lord. Page. There, my lord, 5. My lord, your lordship will find in FTO payment in due, payment due to technical problem. The same will be solved within a week. So taking this remark, advantage of this remark, the petitioner is saying that is not paid. But my lord, the up-to-date lordship, yesterday's, this is 7 February 2026 letter, my lord, though it was written to Commissioner Panchayat, and the other page.
Which one?
My lord, the page, my lord, the back page of this page, my lord, the print taken in both page. I'm sorry, my lord. That this is the, my lord, statement given by block development officer that entire payment has been cleared. If he says, my lord, something which is not correct, then he will be then responsible. And if the petitioner says that as on today, if he is not getting, he has not received 1,61,000, then he should face, my lord, because making a wrong statement will, my lord, will be damageable for both, my lord. The block development officer as well as the petitioner, because block development officer says it is cleared, my lord. This is the statement, my lord, 1,61,000.
Just a minute.
At the time of filing of my affidavit, that was not, oh, it was, my lord, deducted from the account of the department, but it was not transferred due to some technical problem. So that remark was given, my lord, by the BDO, my lord. As of now, it is cleared, my lord.
Just a minute, just a
Lordship,
minute.
lordship.
Oh, where is the original work order? For that particular colony.
Order is not. Lordship will find the.
Where is your,
pending
where is
material-
your, where is your direction disposal?
Direction.
Disposing of the writ petition?
Yes, Lordship will find at page, start from page 11.
Page 11.
Yes.
Just a minute.
11 portion, Lordship.
Just a minute.
Yes.
Where is the matter regarding Kolioni? Kalioni.
Lordship will find a
Because you
paragraph.
mentioned about two things. Raised platform,
Yes, Lordship.
right?
Two-
At
two sets of-
Lohangaon.
Two sets of bill, Lordship. One
Right.
is- Yes,
Just
Lordship.
follow me.
Lordship.
Two work orders. One is raised platform at Lohangaon,
Lordship.
near Namghar.
Lordship.
And second is art filling and land development,
Yes,
right?
yes.
At Kolioni,
Lordship.
right? Total value outstanding liability according to you was 28 lakh
Lordship.
26,895,
Lordship.
right?
Yes.
Where is the breakup of the two work orders? Anywhere in this document
Lordship will find
is, if it is possible, is show me the two work orders.
work order is not annexed, but Lordship, I can show the
1 minute.
list of pending material bills, Lordship.
No, but I want to see the work order.
Lordship, that is not.
Definitely there is breakup. There is breakup.
Mal.
There will be breakup.
Yes,
Is it not?
yes. Lord, regarding breakup, Lordship will find,
There will be breakup.
regarding the second, Lordship.
That report is 21/6/2025,
Lordship.
right?
Lordship.
So far as raised platform at Lahongaon is concerned, scrutinize both the schemes.
Lordship.
And thereafter it was observed, right, already,
Lordship.
no material payment should be made against non-permissible scheme.
Lordship.
So far as
The first,
yes, raised platform.
yes, after that.
So total payment claimed by you is 28 lakh something.
Lordship.
Or it is the breakup between two work. Total was 28 lakh
Lordship.
for both.
For both, Lordship.
What was the breakup?
Break. But Lordship, I can show one letter of the video where Lordship second part, Lordship, bill amount has, Lordship, the amount has been shown, Lordship.
Where is that?
Lordship will find that in the affidavit of the respondent number 1, paragraph, page 45, Lordship. Is a letter of the video, Lordship. Page 45. Page 45, Lordship.
Is
45. In the affidavit of the respondent number 1.
where is the work order? Video. No, it is the commissioner or secretary of the department. These videos, we cannot go by their report. We know what happens. Where is that? List of non-permissible works. So there must be a breakup between the two. One has been held to be non-permissible, right?
Lordship, that is, I'm not agitated.
Right.
Lordship.
So if it is, the second is second
Lordship.
project, Kalioni, the report says clearly that it was completed to the extent of actual artwork 8,605.44 cubic meter.
It was Lordship.
That was a report. No, we are into
Lordship.
the direction is to verify.
Verify the pending bid.
Right. We are not into what your claim is. After verification, whatever is found. That is why I have been telling you that what is the value of the work as per the work order. After verification by a team of experts, they have held that it is 8,605, which is 86.99%.
It was measured
of the completed work. We are not into other aspects. We are into the direction made in the writ petition, verify and disburse to the admissible amount. Admissible amount is 86.99%, which is equal to 8,000 something. So if it is, the total amount released is 7 lakhs so and so. If the work order was for about 10 lakh, then everything is done.
No, work order, Lordship.
No,
That's why I'm referring
no,
this.
no, that is why I have asked specially, don't go here and there. Get the work order from your client by WhatsApp. No point dragging this matter. No point dragging this matter. Get the work order or get the work order by 2. That because of the confusion created, things are
Lordship, give a short date, Lordship.
No. Bill amount is there. It is statement is there. Entire is paid. What more is keeping? No point. For any other claim, you have to make civil suit. You have to institute civil suit. So for bills are concerned, 5 bills, all 5 bills according to them are paid to the extent of rupees 9 lakh something or 7,54,000 something. 9 lakhs.
9 lakhs.
Which is
54,000.
if it is to that equated to this 88,600 square meter cubic meter, matter is in. For other relief, you have to go to the civil court if you are still agreed. We are in re-jurisdiction.
I understand that, but Lordship, this was done after 5 years.
Of the view that no repetition without the admission of liability by the head of the department should be entertained. Henceforth, perhaps
Change something.
the approach is to be changed. All this verify business has created all this. Then all these videos and all are involved.
Correct.
After inflated amount of liability is claimed. An executive engineer, assistant engineer.
This is the work order. Amount is not mentioned, Lordship, only
Yes.
389 tractor with trolley. Are to be supplied against 389 tractor with trolley. And after
Quantity 3534. Kali. Proposed site. Kali.
bills were prepared by the department. We have completed lordship at that time and it was measured. Thereafter, lordship, petitioner's bill were
Not
up,
to be supplied.
lordship.
Amount is not mentioned.
Amount is not mentioned.
Then
Lordship, bill also, lordship, they have prepared, lordship.
bill cash, total cash payment. These are
No,
cash payment already done.
No, not done, lordship. This is bill prepared. After that, lordship, these bills were uploaded in their MIS, which I have annexed in the writ petition, lordship.
Which one is to be believed? Because there are different figures. If seen
And this
two bills.
and this verification was done almost after 5 years, lordship. It's a land fill up, lordship. 5 years rainy season gone, lordship.
That is why verification was ordered by the, otherwise all this disputed question cannot be gone into.
But lordship,
That
after
verification exercise you have accepted. If you have any other claim, you have to take resort to other remedies. That is a problem. Problem is that admission of liability should come from the head of the department.
Yes.
Right.
But he has, malad, placed it, malad, I do not know. This is, malad, we have received, malad.
This one.
And regarding the lordship,
Supply will abide by so and so. There is no mention of.
No mention, malad. Amount, malad, no mention,
No mention.
malad.
One is colony. 89 tractors with trolley are to be supplied.
lordship, I have supplied, lordship. They have calculated, they have prepared the bill, lordship. The bills were
No.
prepared.
Question is, place a document from the commissioner admitting liability. The jurisdiction is very limited.
Lordship, I
Right.
understand that, lordship.
And in fact, we are going ahead with Tamsar-Ali, but
Lord-
Tamsar-Ali was one-time exercise.
Lordship.
Tamsar-Ali was not for all the times to come.
Lordship.
But here is the case, your remedy is actually before a Supreme Court, Civil Court, not before in a rejuvenation.
Apart from that, lordship, regarding their amount, lordship, one bill still not paid, lordship. I have taken instruction that it's not been credited to his account.
No, we are limited to the direction at page 13, 14.
Lordship.
Nothing beyond that. One is that verification.
Lordship.
Second is that after verification, admitted liability should be paid. And Tamsar-Ali, developer Tamsar-Ali, person, right? Right. And secondly, that admission of liability should come from the head of the department. Third, and I reserve the liberty. I will reserve the liberty.
Regarding their lordship admissibility amount also, lordship, some payment has not been made, lordship. That has to be looked into, lordship. 161, lordship, I have taken instruction, lordship. He had checked his account, lordship, and that last bill, lordship, as per that,
1,61,521.
that has not been credited to his account.
Okay, if not done, pay it within 2 months. If not paid, you have a claim to approach this court again for seeking that amount by way of contempt petition. No point keeping it pending. Heard Mr.
S.K. Singh.
S.K. Singha, learned counsel for the petitioner. Miss Das, many times amended cost title, no? Miss Das, you appear for whom?
3 months.
1. Miss N. Bora, learned counsel for the respondent number 1. And Miss Das, video.
Video, ma'am.
Okay. Learned counsel for the respondent number 3. Full stop. This contempt petition under section 12 Contempt of Courts Act 1971, read with Article 215 of the Constitution of India, preferred, alleging that there is non-compliance of the direction given by this court in an order dated 28/2/2024, passed in a writ petition, WBC number 104/2024, which was preferred by the petitioner. The petitioner, in the writ petition, the petitioner had averred that in respect of work orders granted to the, awarded to the petitioner in respect of two schemes, namely, 1, page 12, raised platform at Lohan Gaon near Namghor under MG Nrega 2021-2022, and 2, art filling, underline cross, and land development at proposed site of EMAY-G colony at number 2 Kalioni under MG Nrega 2021-2022. The state respondents did not release his outstanding liabilities amounting to 28,26,895 till the date of filing of the writ petition, despite execution of the two schemes fully by the petitioner. Full stop. Para. The court. The writ petition came up for consideration on 28/2/2024. Full stop. The court took into consideration the decision of the full bench of this court in the case of Tamser Ali versus State of Assam and others, 2008, 4 DLT 1, to observe that any contract amount payable would have to be approved, admitted by the head of the department. Full stop. As the Commissioner, Panchayat and Rural Development Department, Government of Assam, was the head of the department in respect of the two schemes, contract works, against which the petitioner had claimed the amount, the court directed the Commissioner, Panchayat and Rural Development Department, Government of Assam, to re-verify the bills under Nrega, which was found annexed to the writ petition, pending material bills under Nrega, by the concerned block development officer found annexed to the writ petition, in relation to the petitioner's claims. First off, the court further directed that if upon verification, it is found that the petitioner is entitled to some outstanding amount, then the admitted liability should be paid by the respondents. First off, the court directed to complete the entire exercise within a period of 2 months from the date of receipt of a certified copy of the order. First off, para. The petitioner stated that after stated that the copy of the order dated 28/2/2024 was duly submitted to the respondents included herein. On 3/5/2024. Full stop. As the amount claimed up by the petitioner was, as the exercise directed by the order dated 28/4/2024 was not completed within the time period mentioned therein, the petitioner has approached this court by the present contempt petition. Full stop. Para. The respondents. The respondent number 1 and the respondent number 3 have brought their stance by way of affidavits in opposition. Full stop. The respondent number 1 in the affidavit in opposition filed on how many you have filed? 1 or 2? I have filed on 16/5/2025. Has inter alia stated that on query being raised, the Chief Executive Officer, Lakhimpur Jila Parishad, via office letter dated 8/7/2024, had stated that the vendor, i.e. the petitioner, supplied only few quantities of items stroke materials at the work site during the time of execution of the work, and the same way recorded, and payment for any liabilities pending against the schemes to be cleared, if admissible. Stop. As regards the scheme, art filling and land development at proposed site of PMAY-D colony at number 2 Kalioni under MG NREGA for financial year 2021-2022 is concerned, it is stated that the scheme has been marked as ongoing in MIS without entering material bills.
Lordship, that is, I have disputed that is not ongoing, that is completed as per Lordship pending material bill.
I am making,
Lordship,
and giving dictation as regards the stand taken by the where is the direction to constitute the team? You showed me something. 100. 100. Full stop. From the affidavit in opposition, the respondent number 3. It is discernible that by an office order dated 5/8/2025, the respondent number 1 constituted a team of 3 officials of state headquarters to physically verify and ascertain the actual volume of art filling done in respect of the scheme. Repeat query. Polioni. Full stop. The team so constituted went for physical verification at the site on 21/8/2025 and submitted an inquiry report, which is found annexed as Annexure 2 to the affidavit in opposition of the respondent number 3. Full stop. As part of verification inquiry report, the team, after field verification, found that the volume of artwork done the volume of actual artwork done was 8605.44 cubic meter, which was 86.99% of the compacted volume after considering shrinkage as per the working estimate. It was further observed that a proper site survey and cross-section method of artwork calculation were not undertaken prior to the preparation of the estimate, and the same had led to an overestimation of the project volume in the official documents. Full stop. Subsequent to submission of the inquiry report, The Chief Executive Officer, Lakhimpur Jilla Parishad, wrote to the Commissioner, Panchayat and Rural Development Department, Assam, by an office letter dated 2/9/2025. Stating inter alia that after carrying out technical verification and submission of report, the admissible amount had been assessed at rupees 9,54,850. Full stop. It was reported that the material bills allowed for full stop. A statement of payment details made to the petitioner. I don't know. This is issued under the hand of the Block Development Officer, Lakhimpur Development Block, issued under the hand of the respondent number 3, has been annexed to the said affidavit in opposition, giving breakup of 5 bills with their respective bill amount. Full stop. In the said statement, comma, as per the said statement, comma, out of the 5 bills, comma, 4 bills had already been cleared, and the 5th bill, insofar as the payment with regard to 5th bill is concerned, comma, the payment was in queue due to technical problem. The same would be solved within a week. Full stop. The petitioner has, however, disputed the stance taken by the respondents by filing an affidavit in reply. Full stop. According to him, the bill amount, total bill amount, ought to have been the total bill amount recorded in the MIS on 10/4/2022 in respect to the scheme under reference was rupees 25,74,490, and the said amount had to be treated as an admitted liability. Full stop. It has been further averred that out of rupees 25,74,490, an amount of rupees 7,93,169 had only been paid by the respondent number 3. So, para. As regards the scheme named raised platform at Lohangaon near Namghar under MG Enrega 2021-2022, comma, the respondents have taken a clear stand that the said scheme is not a permissible work under the MG Enrega as per para 7.2 of the annual master circular 2021-2022. And as such, no material payment can be made against such non-permissible scheme. Full stop. Clara. The it needs to iterate that the full bench of this court in Tamsir Ali has observed that a writ petition involving contractual liability can be considered only in the event there is admission of liability certified by the respective chief engineer in the works department and in respect of other departments by the head of the departments. Full stop. In the case in hand, comma, as there was no admission of liability by the head of the department, that is the Commissioner, Panchayat and Rural Development Department, Assam, in respect of the two schemes against which the petitioner had claimed the amount against the execution, comma, the writ petition was disposed of with a direction to the Commissioner, Panchayat and Rural Development Department, Assam, to make a verification. And upon verification, comma, it is found that the petitioner is entitled to any amount, outstanding amount, then the admitted the liability to the extent admitted should be paid. Full stop. Para. The stand taken by the respondents, number one, is stand as regards liability taken by the respondent number one is found to the extent of rupees 9,54,850. Full stop. Para. Miss Das has placed on record the status of payment details against the scheme art filling and development at the site of PMAY-Z colony at number 2 colony under MZ Enrega 2021-2020 as under. Full stop. Relying upon the above statement, Ms. Das has submitted that the entire amount of rupees 9,54,687 has already been paid to the petitioner. Full stop. Mr. Sinha has, on the other hand, disputed to the extent that the final bill amount, the fifth bill amount, shown as rupees 1,61,521 has not been received by the petitioner till date. Full stop. Para. Having regard to the direction made in the order dated 28/2/2024, this court, after consideration, has found that the respondent number 1 had carried out a verification process to ascertain the extent of work completed against the scheme number 2 Polioni by constituting a team of technical experts. And it was on the basis of the report submitted by the team, the liability to the extent of rupees 9,54,850 had been admitted. Full stop. Taking into consideration the scope and ambit of contempt jurisdiction, which is only limited to the direction made in the order dated so and so. This court is of the considered view that it is not necessary to proceed further in this contempt petition, as the respondent number 1 had carried out the necessary exercise, as directed, albeit with some delay. Also, para. Taking into consideration the objection made by the learned counsel for the petition with regard to non-release of the amount of rupees so and so against the final bill, this court directs that if the amount of rupees 1 lakh so and so has not been released to the petitioner till date, then the same said amount, the respondent number 1 shall ensure that the said amount is received by the petitioner within a period of 2 months from today. Full stop. Para. It is insofar as if the petitioner has any, it is further clarified that if the petitioner has any further claim with regard to the schemes concerned, The petitioner is at liberty to avail appropriate remedy as permissible under the law before the appropriate. Contempt petition and the further disposal of the contempt. The statement to follow another statement of liability along with the documents placed by Ms. Das is kept with the case record by marking it as document. Next.
Some protection regarding limitation during pendency of before
Article
disclosure.
section 2014.
Further matter for hearing, items 9 and 10.
Oh, Gandhi. Yes.
As a lordship members, there are some queries. from your
Yes, yes, yes. Because we are in dilemma also.
No reply as such.
I put it as a last opportunity so that I can record in the judgment. No reply. একদম খালি লেটার দিও পিন ক্লোজ করে দিব after a vigorous search why zero is missing here? The second line.
Which 0, man?
512. It will be just near AD. It will be 200 AD, not 2000. In this connection, you are requested to furnish the following.
Oh, that was my request, man.
Okay, okay.
That was my request. The
Where
second,
is your reply?
the second one, it is Five to 2026 later.
That is the second line I have said. After a vigorous search.
Oh. After vigorous search in the office.
It is just near AD.
Oh, 200.
Is it not interesting? No head or tail.
If nothing comes, then also. If nothing comes, then also.
There is another letter, 7 to 2000.
Yes.
26.
7 to 3 this time.
Perfect.
This 2003 to 2008. Fixation valuation.
So where is the date?
Date is not legible. Next page it appears, the date appears, but it is not legible.
Where is the year?
This is 5th of December 2003 maybe. There is a chart of zonal valuation.
Now, what is the category of land?
This is, my lord, within 1 kilometer radius of
So 50 lakh.
5 lakh. 5 lakh per katha.
Special category? 1 or 2?
It is 2.
For June, special category general. This cannot be taken into account, is it, or notification? I cannot agree. Per katha divided into 2 parts.
Only 3 then again. 3 है. I believe if possible 10 lakh in 1 kilometer. Oh, but
Very unsatisfactory.
I know. No.
K qualita. It wrote a K qualita. Oh, sorry. You are in which item?
WBC 1 to.
Okay. It is already there. What is there? From Mr. DJ Das.
He also spoke, my learned friend also spoke over phone. There is no such satisfactory reply.
As a last opportunity, we will proceed with the materials on record. DJ Das for the petition in 463/2015. For the response number 6 in WPC number 1236/2017. Mr. K. Quilter, learned counsel for the petition in WPC number 1236/2017. And for the response number 4 and 5 in WPC 463/2015. And Mr. B.J. Thalwar, learned senior counsel, estate by Mr. P.K. Medi, learned state counsel for the state response. Are present. First up, Mr. Taludar, learned senior counsel, has placed 2 office letters. Office letter number so and so. And office letter and dated 5/2/2020 and 7/2/2026. And has submitted that as the instructions are not clear with reference to the queries made by this court, a last opportunity of for 2 weeks be granted. The request is allowed as a last opportunity with the observation that in the event no clear instructions are placed, the court will proceed as per the materials available on record. We'll raise the case on
12th.
Hello.
Number 11.
We didn't find.
My lord, in this case, my lord, under orders of this court, my lord, under orders of this court, my lord, this petition was filed against the, my lord, Escort Bank, which is not in liquidation, my lord. Thereafter, liquidator was appointed. Under orders of the liquidator was made party, and he has also filed an affidavit.
Hmm.
I don't find, my lord, the counsel was
Not available.
but he Bordoli was the counsel. He
Oh.
The order passed by the ETF authority under section 14B was challenged by the Escort Bank before the appellate authority, and appellate authority has reduced the quantum of damages without there being a power, my lord. The quantum of damage can be, my lord, reduced.
The petitioner is
The
EPFO organized. Their petition is preferred regarding reduction.
Reduction, my lord. That was reduced undesirable. No power vested on the power is on only on the, my lord, central board.
Legal question.
Legal question.
Yes. Legal question. Then who are the respondents? Other respondents?
No, my lord, so only the, basically only the, though, only the, my lord, liquidator now. Because the Escort Bank has been liquidated, so it's only the liquidator now who has to.
2007. G Bordoli.
G Bordoli.
He is also standing counsel cooperation.
Yes, he is also therefore.
Then I will fix it. That recording is not
That's
representation.
better. It's better when in his presence.
Huh. Mr. P.K. Roy, Learned Senior Counsel, listed by Miss
A.
Miss
Chakraborty.
A. Chakraborty, Learned Counsel, but the petitioners is present. There is no representation, however, on behalf of the respondent number 2. Today on call. Poster. As the presence of the respondent number 2 is necessary for adjudication, this court for ends of justice. Let the case for ends of justice be listed again on so and so for consideration.
17.3. Not much. Deep level.
Item 13. May it please your lordship.
Yes.
This relates to the cancellation of the licenses of the pharmacist. A similar matter has already been disposed of by this honorable court by a coordinate bench. I cannot pray more than that, your lordship.
What will be that?
There was a direction. There was a direction to appear with all the documents because our claim was that there is a stay operating in my favor. That our license.
Cancellation of license.
Pharmacist license.
Pharmacist license.
Yes, your lord.
Where do you stay? Outside?
No.
No, you are in Assam. Because another issue, pharmacist getting like, oh no, that is in Nagaland. Nagaland, what happened? Many pharmacists got the license.
Yes, sir.
Nobody stays in Nagaland. About 500 pharmacists, they with the pharmacist license from Nagaland, all they are staying in Orissa, Bihar, Madhya Pradesh, everywhere. But they do not come to Nagaland. So that is a different matter. Suddenly I thought that.
No, what happened is that, your lordship.
I decided one matter on
32B, they can. They can, but whether they've actually undergone that pharmacist or not, that's a big question.
That is a different matter.
Yes,
Anyway,
your lordship.
Anyway, in what manner it is to be disposed of? Which paragraph?
Your lordship, I'm just.
It would be paragraph 8 if your lordship has gotten.
Para 8, last page.
Yes, sir.
Page 7.
What is the matter about? Let us see the synopsis first.
Yes,
to
sir.
understand.
Yes, your lordship.
Area state councils means not only Assam.
No, they are not in Assam. Admittedly, they are not from Assam. They are from outside state.
Okay.
32B. Now they have received their pharmacist license from other state and they came back here and under this provision, they have converted their license, they have deposited and they have been practicing. Now the only issue was that before cancelling our license, no notice was issued to that. That's a
The
issue of-
petitioners are registered farmers. State council and tribunal have tribunal come in picture. Yeah, synopsis.
When I say tribunal, we means under the jurisdiction of that state, your lordship. Annexure 1, page 68 is a state from where we had the original license, your lordship. Some from Manipur, some from West Bengal.
Any of the farmers in non-event of the license which was silent. Where are the cancellation notices?
Yes, your lordship. The cancellation notices starts at page 186.
Oh, not 126.
186, your lordship.
86.
I'm sorry, your lordship.
All are similarly worded. All the notices are similarly
Yes,
worded.
your lord. Dates are slightly different, your lordship, but similarly.
So 6, 7, and 8 of the judgment. We quote this similarly worded
Yes, sir.
cancellation notice. 6, 7, and 8.
Yes, sir.
The parties have agreed. Is covered by the same. Heard Mr. R. Shinha. Learned counsel for the petitioners. And Mr. M. Bhuiya, learned standing counsel.
Lordship, if possible, can your Lordship record Mr. B. Gogoi's name?
Learned counsel representing Mr. B. Gogoi, learned additional advocate general, Assam, for the respondent number.
All the responses.
It will be all the respect.
Okay, for all the respondents.
Lordship.
For all the official respondents. The petitioners, comma, 16 number, comma, have joined together to institute this petition, stating that they have a common cause of action. Full stop. The petitioners have claimed that they were registered as pharmacists with various state councils constituted under the provisions of the Pharmacy Act 1948. Full stop. Though the petitioners had originally obtained their registration from
Other state.
state pharmacy councils of other states.
That is at page 68, your lord.
So I'll just record that. State pharmacy councils of other of states other than Assam, comma, subsequently they got themselves registered with the Assam Pharmacy Council under the provisions of section 32 small b.
Yes.
And section 32 within brackets 2 of the Pharmacy Act 1948. Full stop. The petitioners have approached this court after they have been served with cancellation notices, comma, similarly worded, comma, purportedly under section 36 within bracket L or 1.
This would be one.
1 within bracket small I of the Pharmacy Act, comma, 1948. Full stop. For the purpose of clarity, comma, the contents of the cancellation, one of the cancellation notice says on different dates in July 2023, June 2003, on different dates. The contents of one of the cancellation notices are reproduced herein for ready reference. It fromot Jagdish Mr. ঠাইত access কৰি দিম আৰু টুত শান্তনু বৰকগতি পেজ 186 এই নামটো access বাকি subject sir madam yours faithfully Esther come secretary. Para. The learned counsel for the parties have submitted in unison that a similar issue has already been decided by coordinate bench of this court, provide a judgment and order dated 6/1/2026. Full stop. Para. The petitioners herein have alleged violation of the principle of natural justice, right?
Yes, sir.
And have submitted that they have been the impugn order of cancellation of their license have been done without giving any opportunity or notice. Full stop. Para. The judgment and order in WBC number 8250/2022 in bracket Deepak Bora and PRS versus Assam Pharmacy Council and 500.
Your Lordship, that's, yes, Your Lordship, that is also quoted in rule, section 36 of the Pharmacy Act.
I'll
wherein
quote 678. 678. That will take care of
Yes,
36
yes,
also.
yes, Your Lordship. Correct.
While disposing of the repetition in Deepak Bora Supra, comma, the court has observed as under paragraph 6, 7, and 8. Para. In line with the direction given in Deepak Bora Supra, this court disposes of the repetition, giving liberty to the petitioners to prefer an appeal as provided under section 36 within bracket 4 of the
Pharmacy
Pharmacy Act 1948. On or before, say. Okay, give us this. This is today? Is 10?
10.
10. Okay. 10 is 10. 10th of March. On or before 10/3/2026, along with all the necessary documents and testimonials, both for revocation of the order of cancellation as well as for consideration of renewal of their licenses. So it is further observed that if the same is not done within the period specified, comma, the same is to be considered by the appellate authority in accordance with law and without insisting on the aspect of limitation as provided under section 36(4). Full stop. The second part is the order of cancellation issued by the impugned cancellation notices would abide by the final decision, which may be taken by the respondent authorities in the appeals after consideration of the replies to be filed by the petitioners along with the documents. The decision taken on the appeals, comma, to be prepared by the petitioner, comma, required to be communicated to the petitioners in writing, and in the process of such adjudication, comma, the petitioners are required to be put on notice for affording them an opportunity of personal hearing. Full stop. The petition is disposed of in the aforesaid terms. There shall be no order as to costs.
Lordship, there was a line that Lordship had dictated. Lordship had stated if the same is not done, but it has to be done, Lordship. Instead of not done, it's done.
No, if the same is done. Okay, okay.
Lordship.
If the same is done. If the same is done.
Much obliged, Lordship.
14.
Yes, Mr. Sharma. Something to do with liquor.
Hello?
Something to do with liquor.
Yes.
How much time you need? How much time you need, sir?
So my yes, black mark. Yes.
Oh, Mr. Boni is there.
Because only the
The matter would likely to be turned out to be critical.
my senior document function because evaluation of documents was done in my favor. It takes some time, I think. Takes some.
Read yourself. Can it be on a fixed date, another date?
Lordship.
On a hearing date?
Very well,
No
Lordship.
doubt. Or before that. Free date. 10-3, 10-3, 10th of March. Or you need earlier.
God bless me, otherwise I may not be busy also.
Huh?
I may not be busy also.
Oh, that is good.
Regulatory again take time. Anyway.
Huh? This is ultimately res extra commercial. 10-3. We hope that you are on the that side.
Yes.
For the benefit of the state.
Yes.
Okay. P. Sharma, Senior Counsel, listed by D. Dole. B or D? D. Dole. R. Gogoi, Training Counsel, Excise Department. And Mr. Asboni. Respond number 8 are present. Full stop. List the case on 10-3-2026 for consideration.
Obliged.